This all began with by going to the Secretary of State's office and inquiring about the question of unqualified candidates being put on the presidential ballot. And not just Mr. Obama, which we'll talk about more in a few moments, but in the end there wound up being 4 other folks that were unqualified, either because they were not even born in this country or were not born under the proper circumstances. The 14th Amendment makes individuals citizens of the United States, and clearly that's true after the 14th Amendment. Before that, being born in this country gave you nothing. If you were born to aliens, you were an alien yourself. But citizenship, and especially natural-born citizenship, is really inherited, and it's inherited, at least in the Italian model, based upon a combination of soil or land and your parents being citizens at the time of your birth. Now, others... But
if all the grandparents are born in Sweden and your parents are born here, then...
Oh, no. It's not even that complicated. Your parents don't have to be natural-born citizens for them to have natural-born citizen offspring. They merely need to be citizens at least one day prior to the birth of the individual. Okay, so there's no legacy that's involved. It's merely that at the time of the individual's birth, the parents both need to be citizens of the United States. Now,
as I understand it, you attempted to serve Barack Obama with this complaint. He never got served. He's now there in the White House in Washington. This can only be about, and that's what you say, whether he can continue to sit as president. How can we issue any kind of order about whether he continue to sit as president if he's not a party to this case?
Well, he certainly had he's been a party to many cases in the past. Okay, he's chosen not to be a party. We certainly went to his residency at 1600 Pennsylvania Avenue. We had a process server go there, and he only relented when he was threatened with imprisonment by the Secret Service.
Well, I don't purport to know that.
We've served him numerous times by Federal Express, by Priority Mail. Every single document that you see in the lower court's docket, and even after we proceeded to the Supreme Court, every single piece of material that it was necessary to give Mr. Daloz has also been sent by registered mail to the office of to the White House. We're not suing President Obama as President of the United States. We were suing him as candidate Obama.
This is not a novel claim, and it is not a particularly distinct claim, though Mr. Paige points to sections of Vermont law where he suggests he can obtain standing, contrary to most plaintiffs in actions of this sort. That reliance is misplaced.
Are there any thoroughly reasoned standing decisions out there?
Several. Many of them most of them are in federal court. Hollander versus McCain, originally out of the District Court of New Hampshire, is a fairly well-reasoned case. But the trial court judge does a good job of pointing to several of them. Berg versus Obama is another. Those all deal with federal questions of standing, and largely this court has found the same standards of standing, and in fact has adopted in Parker federal standing. Mr. Paige also raises the point of Title 17, Section 2603, providing him standing. The trial court pointed out that the specific provision that Mr. Paige is relying on, subsection B, Section 3, which suggests that a contest of an election can be filed for any other reason, claiming the result of the election is not valid. Mr. Paige would argue that means you can file anyone who voted, any voter, can file any claim of any sort challenging any election in the state. And I believe that draws that statute far too broadly. Not only is election a defined term within Title 17, 2103 of Title 17.
Who in your view would have standing for this kind of question? make it less global, make it just a state representative whose the allegation is lives outside the district and living in the district is a requirement, who would have standing for this kind of case?
Well, that particular hypothetical is difficult because Vermont's Constitution specifically grants the General Assembly or the House of Representatives the authority to determine the qualifications of any member, and therefore this court has held that the case is called Kennedy, that in fact this court doesn't have. So
it's your client, Mr. Condos. And there's some technical, he's really a resident of Florida. So I know there was some allegation of that, I think, with respect to the auditor accounts at one point. I'm just making it up just to understand who would have standing.
But if I was a candidate and I thought my opponent didn't have meet the eligibility requirements under the state law for whatever state office I was running for, I'd have standing, wouldn't I?
Certainly it has been suggested in the federal cases that the candidate's challenger would have standing, potentially under a theory of competitive disadvantage. I wouldn't know exactly how this court would rule on that, but I would imagine following the federal precedent, as this court has in the past for Article III standing, that would follow.
And you said that's Kennedy?
Kennedy is the case involving the House of Representatives. That was a specific challenge about, I believe, a vote.
So back on the standing, so the only one you can point me to is an opponent as a possibility for standing, and even there, that's just a possibility.
Well, actually, how about the opposing political party?
I think
as challenging the eligibility of a candidate from the other party, another party.
I think it would depend on the specific allegation and whether there were constitutional rights involved. Specific to this case, the difficulty is Mr. Paige is attempting to gain standing either as a general voter, claiming that his injury, well, it's not entirely clear to me exactly what his injury is, but
wait a minute though. Why isn't that a legitimate basis as an ordinary voter? Why wouldn't a voter have a right to challenge standing in order to make sure that the exercise of the prerogative to vote is meaningful, has some meaningful result?
Well, Your Honor, I think it depends on exactly what the challenge is, but the rules of standing, the constitutional requirements of standing require a specific injury and not a generalized grievance. And generally speaking, as with a taxpayer, a voter would have no more than a generalized grievance. If it was a concern about the conduct of the election, there was fraud, I was threatened by a mob outside and wasn't able to vote, certainly that would provide a specific injury and standing, and arguably that is what 2603 was meant to remedy, was to allow those voters not to have to deal with standing, but in fact to get before a judge and say that there's a case from 1948, for example, where the opposing candidate alleges the lighting was bad and therefore people couldn't read the ballots. That's the sort of challenge.
Don't we as voters have a more direct interest in the purity or lack of corruption of the ballot itself as opposed to some generalized challenge against a policy adopted by statute that really has nothing to do with us directly? I mean, don't we all have a direct interest in who we vote for?
Well, certainly I would argue that the qualifications of a candidate are best vetted by the voters as opposed to any other tribunal. I'm not sure if that's the question Your Honor's asking there. The purity of the ballot, meaning the actual piece of paper, or the purity of the ballot?
Well, the purity of the candidates, the fact that they're supposed to be there or not.
The integrity of the system. How about if you phrase it that way?
I think all voters have an interest in that, but that doesn't provide any given voter with standing to address the issue, because so the reason standing doctrine prevents that sort of generalized grievance is there's no guarantee that the individual who is litigating the case will litigate it with the authority of all the injured parties.
But then there's no reason to have qualifications, right? There's no need to have a provision requiring citizenship for candidates, because no one will ever have. Well, hardly anyone will have a basis to complain.
Well, arguably, the individuals most deeply impacted, those who didn't get a job because they were voted out of office or some portion of their vote was siphoned off because of an unqualified candidate, they would, in fact, have standing, or arguably would have standing, to challenge that other.
I take it in the system, Mr. Condos does not cannot be encouraged to or will not make this determination himself. So let's say Mr. Page goes to Mr. Condos right away and says, Mr. Condos, do not put on the ballot Barack Obama. It would be a violation of the United States Constitution for that to happen. I take it in those circumstances, Mr. Condos says, this is I don't have a dog in this fight. This is not my fight. I'm not going to make that determination.
It's not even clear that he has the authority to do that. Under the law, it's expressed that when the Secretary of State, I guess there are two answers to that. The first part is I don't think under the law that the Secretary of State has the authority to make that call. Secondly, and this is a quote from Keyes versus Bowen, which is a California Federal District Court case from appellate court case. The court, in dealing with exactly that question and the argument of whether or not the Secretary of State should have the role of determining qualifications, said the truly absurd result would be to require each state's election official to investigate and determine whether the proffered candidate met eligibility requirements of the United States Constitution. Essentially, it would subject the presidential nominating process to each of 50 states' election officials, all of whom are politically elected, independently deciding whether a presidential nominee is qualified.
Isn't the fact then the independent election official can't contest this question, doesn't that sort of support the notion there must be standing somewhere to do it, and that it would therefore be more appropriate to let the voters bring suit? Because in the normal circumstance, of course, you would say about standing, well, there's a independent elected official, there is a appointed official, there is an official who looks at this question, decides it one way or the other. You might be able to get review of that official's decision. That's another issue involved, but there's an avenue. Here, what you're saying is there is no avenue. In the absence of an avenue, shouldn't we take that into account for standing?
I guess I would. I apologize if I've given the impression that there is no avenue. Specific to this case, Mr. Page doesn't have standing because Mr. Page is a voter. There are other avenues through which one may potentially be able to challenge this in federal court. In the first instance, the voters are determining the qualifications of any candidate through the voting process. In the second place, a challenger who believed that they were facing an unconstitutionally qualified candidate potentially could bring suit. But I think ultimately it is Congress's role, and a role that has been dedicated to Congress, to determine these issues. Now, whether or not, if you were to liken this to an environmental case where I live in an area that is going to be flooded by a potential dam, that may give me standing, but if I simply enjoy the view of a valley that will potentially be flooded, that doesn't provide me with standing. There may be a regulatory authority who should be looking into that, but they may not be doing it. That doesn't mean that I, as just someone who enjoys the environment, should get standing. It's the same circumstance here with a voter. Simply because the voter believes that a candidate is not constitutionally qualified doesn't provide them with standing, even if there isn't necessarily a ministerial actor within the government who is given that right. If there are no further questions, Your Honors.
Okay, thanks.